the case of the people versus Aaron Hawkins.
Image Sinatra for the people. Hawkins.
What are you? What's these people? Why is he repeating what I say?
Aspirations.
Oh, wow. Okay.
This is Public Defender Jay Bellinger on behalf of Mr. Hawkins, who appears to my right. Your Honor, Mr. Hawkins, can you please state your name for the record?
Aaron Hawkins.
Thank you, sir. All right.
Your Honor, it's my understanding that we're to be asking for a 3-week adjournment on this matter so that we can continue a referral for drug treatment court. Is that what you're being referred to? This is this case. It's not here today. I understand that there's a bond violation in this matter as well. We have discussed that, Your Honor. My client is willing to admit to the violation, Your Honor. He would be asking for a scram tether. He's asking release so that he can continue working. He works for a trucking company. He's not a driver for a trucking company, however, but he would like to maintain his employment. He advises that if he is today that he's going to lose his job. He's hopeful for a scram tether so that we can keep track of him that way in terms of any future allegations, which he submits that he won't have any.
I don't know if there's anything from the people.
And what was the nature of the bond?
On October 26, 2024, at 12 a.m., he blew a .055, then continued to blow numbers throughout the morning through the 26th and admitted to consuming alcohol.
Your Honor, I would just let the court know, and this might be in the bond information. One of his priors is a high BAC.
Yes.
19. This present case, the alcohol level was a 0.17.
Yeah, that is, Your Honor. We would respond briefly by stating that that is why he's trying to get into the sobriety court. He recognizes that he has an issue and he's asking for leniency and getting a scram tether so that he can be better monitored. He did ask for that at arraignment. He wasn't given that, however, but recognizes that there is an issue.
What are you asking me to do with the case?
Adjourn the matter for 3 weeks so we can continue the referral.
Tell you what, I'm going to adjourn it out 1 week to September 5th, 2024, 9 a.m. But at this time, until he's got something in place, he isn't even going to have anything in place, does it?
He does have the
what?
The portable, Your Honor.
Yeah, that didn't do any good.
I understood.
I mean, I'm talking in terms of any treatment, anything. What's he doing in terms of any treatment?
I'm sorry?
What's he doing in terms of trying to get himself into treatment?
I speak. That's what I was waiting for. I was waiting for the attorney to let me know what I was supposed to do next. That's
in terms of the referral for drug treatment court, Your Honor, with Judge Conkey.
Right, but you can get yourself into treatment.
Have you done anything?
You're now here on your second drunk driving. First one was, from my understanding, a high BAC.
Right.
You don't even make it through a couple of weeks in terms of a bond condition of being on the sober link before you're blowing numbers, and you're not blowing them at a low rate. If you didn't have an attorney, you still have a problem and you need to deal with that. So don't try to blame somebody else that I'm waiting on something. I'll put his probable cause hearing out to the 5th. So I'll give a 1 week adjournment, but at this time, defendant's bond is revoked, defendant's remanded.
Thank you.
Court does call the case people versus Timothy Cottenham. I'm picking a different language.
And good morning, Your Honor. Good morning to your fine staff members. Edward Martell, P. 85051. On behalf of Mr. Timothy Cunningham, who stands to my right,
Sir, please state your full name for the record.
Timothy Cottingham.
Thank you, sir.
Thank you, Judge. Today's date and time for probable cause conference, just recently retained, have touched base with sister counsel, have requested discovery. My client's been fully advised of his constitutional right to an examination within 21 days, considering the recent retainment as well as the discovery issues. At this time, he's wishing to waive that 21-day rule and set this and respectfully ask this honorable court to adjourn a probable cause conference for a period of around 2 weeks, Judge. Please and thank you.
2 weeks. That objection, probable cause, September 12, 2024, 9 a.m. bond continued.
I'm sorry, Judge.
12th?
9/12,
Yes.
10 a.m.,
9 a.m.
9 a.m. Judge, may I briefly address the issue of bond?
Sure.
Thank you. Judge, as this honorable court is aware, bond is not meant to be punitive. The current bond is $1 million cash. Bond is certainly not meant to be punitive. It is meant solely for flight risk and danger to the community. And the court must consider both the history of the offender and the nature of the allegation, Judge. In this particular case, we have a young man with no prior felony convictions, no prior domestic violence history. We have two individuals that have a child in common. Judge, notwithstanding the allegations, Judge, at this time, the $1 million bond is substantial. He's 27 years of age. Again, no prior felony convictions, no caprious history. So certainly not a flight risk. We're talking about danger to the community. This, again, is not a random individual. The two have a child in common. So we really are talking about purported danger to the current complainant, Judge. Certainly there are mechanisms or conditions or set of conditions which could circumvent any of these concerns of the court, namely GPS tether, house arrest, third-party custodian. In the courtroom is his mother and his wife, Judge. He is, again, married, 4 children, 2 of which are autistic, that he is the sole caretaker provider for as far as financials, Judge. If this young man is not released back into the community and allowed to work, frankly, they're going to be homeless, Judge. Not only is he not going to be able to provide for this family, but he's not going to be able to provide for the complainant and her child, Judge. So we're humbly asking for a fair and reasonable bond, Judge, of $50,000, 10%. Again, bond is not meant to be punitive, and that is enough to ensure that this young man comes back to court, 1, and 2, and that there's no danger to her. Again, and they've known each other for 15 years. There's no prior domestic violence allegations between the two during that time, known each other since middle school. Ultimately, we're asking for home confinement with permission to go to work, Judge. Please and thank you.
Just before I hear a response, I have the information provided to me, counsel, is that he does have a prior conviction of some type.
Correct. No felony convictions, no domestic. Is that correct, sir?
Yes.
What was that one for?
I believe it was some type of misdemeanor conviction.
Assault and.
So you got a prior assaulted
No,
conviction?
He has a 17-year-old juvenile conviction for assault.
Counsel, I have that his adult criminal history includes at least 1 misdemeanor.
That is correct.
That's what I'm asking.
What is the misdemeanor for criminals or for adults, sir? Do you recall?
I'm not sure.
Okay, and also in terms of that, I also have it, and again, counsel, this is the information that's provided
Yes,
to me and provided to that either from that or from something else, he has 2 previous failure to appears on some.
I was aware of one.
Hold on.
That's
And I do understand, Judge, the position of the court. I do have his mother in the courtroom who's contesting same. However, Judge.
okay. That's fine. I'm just telling you what I have.
Thank you, Judge. And notwithstanding same, Judge, there's certainly conditions or set of conditions that can circumvent any of these cares or concerns of the court. Namely, again, home confinement. I don't believe that was ever utilized in the past. Like, he has not 1 retained counsel, but 2, myself and Mr. Nassar, Judge, we're certainly ready to address this on the merits.
Response from the people.
Judge, we had actually asked for originally a $5 million bond in this case. This is a highly concerning case with the victim, and I safety. This arises from a relationship between the defendant and victim, where the defendant didn't want the victim to tell anybody that she was pregnant, and literally told her that he was going to beat the shit out of her and make her feel good and do it in front of the kids. told her that she was gonna slowly cut them all, over dragging them, just enough to keep them conscious and pull their nails and teeth out. Then he goes over to her residence. She was in the shower at the time. She went downstairs. He starts buzzing, doorbell's trying to get into the apartment building. She's not letting him in. Someone else lets him in. He immediately opens the door, grabs her by the throat with one hand, slams her against the wall, strangling her, lifting her off the ground. She ended up having to go to the hospital that night, and she had fractured her back. This is extremely concerning in the situation. The prior and coming over to the apartment and doing what he did to her. I have extreme concerns for this victim and her safety and her children's safety.
Judge, may I very briefly rebut?
Well, I just want to also make sure that there were the back injuries. I see the notation of a fracture to her back. It's also relayed to the court that the victim at the time could not stand or walk. Is that correct?
That's absolutely correct.
Go ahead, counsel.
Thank you, Judge. And notwithstanding the allegations, certainly my client stands here today with a cloak of presumption of innocence over him, Judge. Now, this allegation that never wanted to have the child, they have a child that's 2 years old in common, that's 2 years, or nearly 2 in common. So that's, hardly irrelevant, Judge, for lack of better terms. And as it relates to the purported injuries, well, one, when the paramedics arrived, whatnot, she was standing there when she was found. So I don't want to get too much into the marriage, Judge, but again, it's flight risk and danger to the community, Judge. There's conditions that could.
Yes, counsel, but what makes it a danger to the community is that when somebody who may be pregnant ends up with a fractured back, and the indication that I have is that she cannot walk or stand, that's a danger.
No dispute, Judge. Respectfully, I don't believe that there's an allegation she's currently pregnant.
That's not. I have down that the defendant and victim have a child in common. Victim has another child. Defendant is married to another woman, and victim reports the defendant and victim had a casual relationship that resulted in pregnancy.
Got it. That resulted in pregnancy.
And I certainly understand the concerns of the court, Judge. But to be fair, a $1 million bond is traditionally reserved for homicide cases, Judge. In this case, in this particular case, Judge.
Not in this county, but go ahead.
Thank you, Judge. Respectfully, Judge, we're just asking for a fair, reasonable bond that will ensure that this young man comes back to court, which I'm confident he will, number one. And number two, ultimately, that they don't have any communication.
Have you read through the discovery thus far?
Very briefly, and I've spoke with his counsel as well.
So I'm not saying that I may not look at it, but based upon the allegations that I have at this point, I would consider this individual to be a high risk to the community, given the circumstances. I think when you look through everything, then maybe there might be an argument where the court would change its mind. But with what I have in front of me at this point, I think that the bond is appropriate.
Would Your Honor consider a 10% provision?
No, at this point.
Thank you, Judge.
I'm going to tell you, go look at all of the discovery, go through it. And I'm sure at the next hearing, you're going to raise some argument again, and that's fine. I'll hear it. And if you want to file a written bond request, we'll be more than happy to hear that. But based upon what I'm hearing right now, I think that this bond is appropriate given the nature and injuries and what this court would perceive the defendant as being a risk to the community.
Absolutely. Thank you, Judge. Always a pleasure.
Thank you. We'll continue. It's set for the 12th. Okay.
Ready, Judge. Assistant Public Defender, appearing on behalf of Ms. Kern. Ms. Kern, please state your name for the record.
Julia Michelle Kern.
Thank you, Judge. I've spoken to Mr. Ganatra on their file, and I have tendered a police report and an advice of rights to the court. I don't know if it made it to the file. Ms. Kern just changed her mind and decided she wanted to take the plea. But if
wants to,
she does want to do it. So if it made it, we can do it. If not, then I'm fine to adjourn.
I don't I don't have anything.
Okay.
So, just so the court knows, Mr. Feaster and I were in communication yesterday, and the last communication, I had sent him a plea form.
Yes.
But I did check guilty, not no contest, and it also said if it meets the requirements that your client wants, then forward it to the court. So I left it to Mr. Feaster.
He did. And I forwarded that.
And so you, what?
I spoke to her.
Okay, that's good.
I forwarded this morning. Just had a conversation with she and I believe her mother. And they just decided that they did want to take the plea.
That they did.
They do, yes. So if you have it, we are prepared to do it today. If not,
I'm short-staffed, but
I apologize.
Julia, is this what you want to do?
I wanted to talk to a paid lawyer, but my mom.
A paid lawyer?
Yeah, my mom, dad go against that.
Why, you think that's going to be better?
I don't know. I wanted to-
I'm going to tell you this, Julia. Have I ever lied to you? We've known each other for like 50 billion years, right?
No, you haven't.
I will be honest with you. I mean, you can do whatever you want.
Yeah.
You're not going to get anything better than Mr. Feaster.
All right.
It just won't happen.
All right.
So, I mean, but if you want to spend your money and waste it, go ahead.
That's the problem. I don't have any. So I don't have any money.
Okay.
Yeah. So I think I'm just gonna go with the plea tonight.
Okay,
All right.
but I mean, did you want to? I mean, I will give you time if you want to talk to somebody else about what to do.
I think my mom is just done with coming to court.
Okay, Julia,
Yeah.
your mother was done coming to court with you about 15 years ago.
Yeah.
All right, but she's still here. God bless her. All right, so let me then. I've got the plea form. I don't have.
I only have a guilty plea form.
Yes, guilty plea is fine.
She's going to plead guilty.
Correct. Yeah.
Okay. So I've got an advice of rights. I have that. It's my case. As I think all of her cases are written, so.
I believe so, Judge.
Julia, that's what you want to do then?
Yes.
May I have her sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Julia Michelle Curran.
All right, Julia, it's this court's understanding that you're going to be pleading guilty to 2 charges of attempted resisting and obstructing. Those are misdemeanors punishable by up to 1 year incarceration and a $2,000 fine plus court costs. Do you understand that?
Yes.
All right. In understanding that, you still wish to plead guilty?
Yes.
So to the charge of attempted resisting and obstructing as contained in count 3, how do you plead?
Guilty.
To that same charge as contained in count 4, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights for today, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yeah.
Are you on probation or parole?
No.
Has anybody promised you anything
No.
other than what's been stated here today, that's dismissal of counts 1 and 2 to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will,
Yes.
right? And because you believe that you are indeed guilty of this offense,
Yes.
these offenses?
Yes.
All right. November 2nd, 2023, at the location of 5201 Buckley Drive, Pittsfield Township, Washtenaw County, State of Michigan. Did you come into contact with 2 officers from the Pittsfield Township Department of Public Safety?
Yes.
What happened?
I resisted.
All right.
How?
I kicked and screamed and spit at them.
Okay. They were trying to what?
Take me to the psych ward.
Okay.
Yeah, I was in psychosis.
Got it. And so you kicked and screamed, spat at them, and didn't comply with their orders and requests. Is that correct? All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
That's fine.
Yes, Judge.
Court will accept the defendant's plea of guilty to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered. Sentencing in this matter will be
September 25th at 1 p.m.
September 25th, 2024, 1 p.m. Before me.
Thank you very much, Judge.
Thank you, Judge. Good to see him.
Good seeing you, Julia. When you go over, stop down the hallway and check in with Miss Plea.
Okay.
All right, so that we can start that whole process and get it done.
Okay.
Okay, thank you.
Thank you, Judge.
Mom, take care. You're welcome.